Hello and welcome to LawHelp Australia, where we keep you informed and safe with tips and updates. Today's focus is on drink driving under criminal law, driving under the influence, without license or while suspended, infringement notices, blood tests, court process, pleading guilty and more. Today we have an expert panel. Let me introduce Tim Bourke, Barrister at Law. Tim, tell us a bit more about yourself.
Oh, thank you, Dinesh. I practice in a broad range of law. I do a lot of criminal law as well as commercial general litigation law. But I've been doing a lot of .05 since I've been at the bar. I've been at the bar now for about 10 years. Prior to that, I was working as a commercial solicitor, and then prior to that, I was working as a registrar at the Magistrates Court. So I saw a lot of .05 and a lot of practitioners coming before the court.
How long have you been practicing, Tim?
12 years, 14 years.
We've got Robert Stary from Robert Stary Lawyers.
Thank you. Yes. Well, I've been practicing for 33 years. I'm the veteran in the group here, and I've been an accredited specialist in criminal law since 1995. And we've got a large practice. We deal with a lot of drink driving cases because more so now than ever, people who drink and drive, particularly if they've got previous convictions, are at risk of imprisonment. And so, although overwhelmingly a lot of people plead guilty, sometimes they're at risk of imprisonment. So it's a large component of our practice.
Chen Yang,
Yes.
tell me a bit about yourself.
Well, I'm the spring chicken in the group. It looks like I've been practicing for about 3 years. Practice at Vale criminal law. We've been, as with Robert, our practice has a lot of drink driving component to it. We get a lot of drivers who come to our firm the first time. They unfortunately get into trouble. We also have a lot of people from different cultural backgrounds, especially the Asian background, who come to our firm. And it's difficult to explain to them that their concept of traffic offences in Asia are very different from Victorian traffic offences.
Yes, where do we start? 0.5, little bit more, little bit over.
Well, one thing I was going to say is that there's very little tolerance now. Once a person's over exceeding .05, even if they're a first offender, unless their reading is below .07, there'll be a mandatory suspension or cancellation of their licence. And that will be ordinarily for a first offender with a reading of .07 or less, it'll be 6 months. And then there's a correlation between the blood alcohol reading that the person might have and the period of suspension that they might have. And usually first offenders are dealt with by way of a traffic infringement notice. They're not required to go to court.
Tim, Rob mentioned 0.7. What about 0.5?
Well, if you're over .05, you will still be charged, and if you're between .05 and .07, there is a discretion both by the courts and by the police to not take your licence. If you're in actual fact, I think under .06 is where they'll issue with an infringement notice on the spot, and you won't lose your licence. But if you do lose your licence and you get 6 months loss of licence by the infringement notice from the police on the side of the road, you have the ability to appeal that and take it to a court to satisfy a magistrate as to why you shouldn't lose your licence.
So 0.5, there is a discretion to the police, Chen?
Yes, there's a discretion as to whether they serve you a notice of suspension immediately. Think in relation to whether they have to cancel your licence immediately. If you blow 0.1, they have to serve you with a notice of suspension immediately.
That's mandatory, I guess.
That's mandatory, yeah. And as Tim said, then you can take it to appeal the suspension. However, probably get some legal advice before you ask to suspend or to appeal it.
What it is under Section 51 of the Road Safety Act, if a person blows over .10, or if they have a prior offence for .05, the police have the power to suspend their licence immediately on the spot. So you'll drive home on a Saturday night, you've had too many drinks and you blow .11, you will lose your licence immediately. What Chen's saying is you then have an ability to appeal against that to a magistrate to have your licence back pending the outcome of your hearing. It is a difficult test to get over, and it's become more stringent in recent times by the way the courts have interpreted it. But it's basically...
It's very rare, isn't it? Even if you're working or their family commitments. Even though you normally have a presumption of innocence, you trigger the suspension once you're over a certain limit, and it is hard to get your licence back. Very rare, in fact, to get your licence back pending the final hearing of the case.
It's the exceptional circumstances
It is,
test where you might use a combination of factors, that you've got a child that has to go to the Royal Children's Hospital twice a week for blood tests, or you need to work in Frankston, or you have other particular reasons why you need your licence. But it has to be something exceptional, not just something
Very
and you're the only driver in the whole family. So just because you wanted to take your kid to school every day is usually not good enough, or you have to go to work every day.
So what you're saying is it's strict liability, there's no discretion, but it seems to be that there is a discretion as well on those grounds.
Well, there's a very narrow window of opportunity if your reading's between 0.05 and 0.07, where you're permitted to keep your licence, but you are then, you attract a number of demerit points, 10 demerit points as well. So you're vulnerable one way or the other. 10 demerit points, and that operates separately to any other suspension that you might get. So there's a narrow window of opportunity. In fact, 0.05, like speeding offences, really is a form of mandatory sentencing. Once you're at a certain level, it triggers certain responses, particularly in terms of cancellation.